Um, my office in particular is responsible for ensuring that the best interests of children are upheld in such matters. I neglected to mention that we're also involved in guardianship matters as well. So yes, I appreciate the opportunity to speak to you today, to address you on these aspects. Let me start out by saying that children are our most vulnerable members of society, and we all have a duty to ensure that we take care of our children in all aspects, in all matters pertaining to their well-being, um, um, their protection. This extends to a child's right um, to be cared for emotionally, physically, financially as well. Um, and that's where advocate raters and myself or and our colleagues come into play. The Family Advocate's Office itself is mandated to attend to care and contact and guardianship matters. When I say we are mandated, I mean that we receive our authority to attend to such matters via the court. So that comes in the form of a court order, um, where we're asked to specifically investigate into best interests of a minor child. And if there are other aspects that are related to best interests, the court will specify. We are also mandated to attend to matters where there is a pending matter at court and either one of the parties requests family advocate intervention. So our intervention involves investigation into what is in the best interest of the minor child, and so that's one aspect of family advocate engagement. The other aspect comes in the form of what we call mediation or mediated matters. We approach those types of matters in the form of alternate dispute resolution. We call it ADR. Those are matters that our current father might be wanting to acquire full parental rights and responsibilities. This father will come to us and request. It can also come in the form of, like I said, where matters have not yet reached court stage, but parties want assistance to arrange a care regime with the minor child. We assist with the drafting of parenting plans. It's not always very simple because it's not always the case that parties are able to agree with each other. And it's in those instances, we must put our best mediation skills to the test to assist the parties to come to an agreement. I want to just go through a few of the relevant sections of the Children's Act that is important in relation to the subject matter. So I said to you that we all bear responsibility to provide um, emotional, physical, financial care to a child, but a parent's responsibility is in fact is quite important and requires or has definition in terms of the Children's Act. So the Children's Act includes protection as well as the rights and responsibilities that a child is entitled to. So the child firstly has a right to parental care to shelter, to food, to an identity as a person, and to have contact with their parent and significant other parties or people in their lives. This includes grandparents and extended family. Like I said, parents have a responsibility, a great responsibility to provide care, the emotional support, the physical support, the maintenance. Um, so when I mentioned care and contact and guardianship, in a nutshell, this is encompassed in the Children's Act, these rights and responsibilities. One of the um, most popular questions that we get asked is who can acquire rights to a child? Is it only the parents or biological parents? So just to inform you that an unmarried father is entitled to acquire rights and responsibilities, either parent, an interested party, like I just mentioned, it can be a grandparent, an uncle, an aunt, and parties who are married through religious rights as well. Section 9 of the Children's Act encompasses that all matters concerning care, protection, and well-being of a child, all of those matters, the standard to be applied is that the child's best interests are of paramount importance and must be applied in all instances. That's very important. We look at Section 7 of the Children's Act, which details, it's not an exhaustive list, but it details various factors that the courts, that the family advocate considers when determining or considering what is in the best interest of a child. Section 10 of the Children's Act is very important. Section 10 of the Children's Act highlights the children's rights to participate in an appropriate manner where their views are considered, or rather expressed and considered. So the courts give way to the child's perspective as well. Without going into too much detail at this point, I'm happy to answer questions, however, at a later stage in this meet. There are various sections in the Children's Act that allows for process in terms of guardianship, in terms of, like I said, parental rights and responsibilities, and securing of unmarried fathers' parental rights and responsibilities. I mentioned a parenting plan. I think I did. A parenting plan relates to an agreement between both parents, wherein an agreement is made between the parties, or parents rather, which relates to care and contact of the child. So it would be all those aspects that relates to the child's residence, schooling, etc., as well as contact with the other party, the other parent. I did say to you that the family advocate assists with the drafting of such a document. A social worker may also do so. An attorney is also entitled to do so. These parenting plans are brought to the Office of the Family Advocate for consideration, and then it is our duty to ensure that the plan or agreed plan between the parents covers the best interests of the minor children in that matter. So we assess, we have a look at the circumstances of the matter. We look at the information that's provided. Sometimes we don't receive all information that we require and we request. We have a look at the information provided, and we indicate in writing whether or not the agreement or parenting plan is considered to be in the best interest of the minor children. Now, backtrack a little bit. You'll remember I mentioned Section 10, which is child participation. We also look into the plan to see if it's made mention that the plan was discussed with children and that the children are satisfied with the arrangements that's been made for them. The Children's Act goes on to describe the process that one takes in respect of establishing rights and responsibilities and what the duties are of both co-holders of parental rights and responsibilities, that is both parents or whichever parties are involved in the matter. What's interesting to note and very important is that I don't want to quote the long case law, but there is case law to the effect that the courts have found that children's best interests are of such paramount importance that their interests outweigh the parents' right to religious freedom as well. There is provision in the Children's Act for when a person who has or is entitled to have care of a minor child refuses contact the co-holder of parental rights and responsibilities, being the other parent, in most instances, and refuses that parent or party from exercising their rights, either be it in terms of a court order or agreement, that person who refuses contact is guilty of an offense. And that person is liable for a fine or a period of imprisonment not exceeding a year. So it's very important that if you're struggling with issues relating to care and contact, that you initiate or start the process to establish a parental plan or parental agreement. I want to highlight a few pivotal factors that are considered in care and contact structures. I did say to you, best interest is of paramount importance. Best interests are set up as competing interests to other factors. So other factors would be gender, the reasonable person test and enmeshment of the child's best interest versus the best interest of the parent. Sometimes there's a bit of a blurring when it comes to best interest and interest of the parent. We see a lot of matters where parties are or certain parties are more inclined to follow what the child's preferences are as opposed to what is in a child's best interest. Sometimes socioeconomic situations come into play where, for example, a party has the opinion that he or she is of a higher earning power, and so I can financially look after my child, so my child should stay with me, or I should have primary care of this child. We see a lot of highly conflictual matters where children are most unfortunately drawn into parental conflict instead of the child being placed above the conflict. Quite often we see that children are drawn into the adult issues, which is most unfortunate. Other factors that we see relate to relocation matters. An example of that would be a parent says, I'm traveling, I've got a job overseas, I want to leave the country, and I'm of the opinion that it's in the best interest for myself in terms of my career, my earning power, and it creates opportunities for my child or children to live a certain lifestyle overseas. Quite often, those matters are those matters are quite complicated because on occasion parents see or unable to um, detach from their interests as opposed to their children's interests. Each matter is so specific and so particular. You've we have to approach such matters with some circumspect, and so investigations into best interests in respect of, well, there are lots of factors we look into in those matters. For example, the child's attachments in the country being one of them, and the child, how settled is the child in the country, um, extended family, friends, etc. Um, just to advise some of the trends we see from our investigations. Um, these are quite unfortunate trends, but it's a few negative aspects. Um, quite often, well, I mentioned already that quite often children are drawn into adult issues. Um, and it's quite a travesty when that happens. So they're drawn in by parental conflict. Um, it's also just as difficult and a travesty when we find that um, attorneys and mental health professionals or practitioners, other professionals get involved, and to the point that um, children are overexposed to professional assessments. Um, we see that happening quite often. Um, we also see um, quite often we see um, sort of, I don't know if I can call it coaching. Um, a parent will have a point of view on what is in the child's best interest, and you find a child supporting and articulating what is the view of the parent, as opposed to this child advising on what is her um, preference. Um, those are some unfortunate trends. Um, um, At the very beginning, I mentioned how the family advocate gets involved in matters. Um, I can't recall now if I mentioned that our investigations emanate from court order mandates. So, what that means is there's got to be a pending matter before court. So long as there's a pending matter before court, we either receive a court order to investigate circumstances, or we receive a request from one of the parties. Um, um, one of the one of the most interesting developments currently, I should say, is that I want to talk about a particular case, just so you understand where we're at on the topic in terms of access to the Family Advocate's Office. Um, there was the judgment. This is called the judgment of ST versus BN and Minister of Constitutional Development and Center of Child Law. It's a bit of a long citation, but you're welcome to query me for the case if you should need it. This is such an important matter. The Constitutional Court in June 2023, almost 2 years ago, 29th of June 2023, the Constitutional Court handed down a judgment that confirmed or declared that the a particular section of the Mediation in Certain Divorce Matters Act to be unconstitutional. So the Mediation in Certain Divorce Matters Act is in fact the primary legislation that relates to the Office of the Family Advocate, and it's where we are legislatively empowered to get involved in such matters. So a particular section of that act was declared to be unconstitutional. So um, this case now provides for an extra provision to be sorry, I have to say my son just interrupted me now. Apologies, I've lost my train of thought. Um, okay, so I found myself again. Apologies. I'm referring now to the Mediation in Certain Divorce Matters Act. And um, what I say to you is that this a particular section in this legislation was declared unconstitutional. So this extra provision that now the court has deemed must be included in the act is that when an application has been instituted by a parent relating to the exercise of parental responsibilities and or rights, or an application to court is made by a non-parent, this is any other interested party, in terms of certain sections of the Children's Act, this person can file what is called an Annexure B with the Office of the Family Advocate to conduct an investigation. The case points to, basically, the case points to extending justice to all without having to obtain or await a court order. So access to the Office of the Family Advocate need not wait for a court order to be granted for an investigation to begin. So any party to the matter where an application has been instituted may file an Annexure B. This relates to matters where not only divorced parties are entitled to approach the Office of the Family Advocate, but any other parent, meaning or non-parent, an interested party to an application. And we've seen an influx of work as a result. And we are most grateful for that piece of legislation. So the impact has been great. We've been involved in all manners or all tiers of courts, be it the High Court, Regional Court, Children's Court, with requests for the Family Advocate to get involved. I'm noting now as I'm speaking to you that the date that this judgment was handed down was on the 29th of June 2023, which means it is almost 2 years later. And I think we will be following up to understand whether or not those amendments to this particular act is in the pipeline. Carly, I think I'm going to hand over to you. We're anxiously awaiting to hear you on your presentation, and I'm happy to take a seat now. If there are questions for me, then I'll be happy to answer where I can. Thank you for your attention.
Thank you very much, Advocate Pile. That I think that lays at quite a ground for us as we go into the next topic on now maintenance and trying to connect the two. I have also some questions once everything is done, as a person who has a bit of familiarity with some of the cases. Thank you very much. Advocate Dion, you can go through. But Tobelani, please. Put on the slides for us. Advocate Dion,
Yes, I'm here.
can you see the screen or it has not appeared also on your side?
It didn't appear yet. It just shows that it started screen sharing, but it doesn't show. Yes, there we are. I can see it now.
All right, thank you.
Can I continue?
Yeah.
Okay,
I'm
colleagues.
you can be
Yeah.
able to do about the presentation within 20 minutes, then we can do about 10 minutes of question because I'm watching the time.
Okay.
We're 20 minutes to
Okay,
7 now.
excellent. I will finish within
All
20 minutes. Thank you so much for giving me a time limit. Otherwise, I can speak for another 4 hours if you don't stop me. I am in the company of a lot of individuals that I see on the platform this evening, and I just want to say good evening to all. And I want to say a special thank you to Ms. Saravani Pillay of the Office of the Family Advocate. And I need to honor our regional lead for the Western Cape, Mr. Rodney Isaacs. I see he's also online. So any questions that you have, please ask me or any of my esteemed colleagues that are also over here this evening. Maurice Steenkamp is an attorney. There's Melissa van der Merwe, who is a mediator. Peter Higo is also in the Department of Justice. And I see there are a few others. Odin Swart is a UWC student studying law, and I see Professor Bayers of UWC is online. So we are in the company. Liesel Conye is also here. So there are a lot of people that know a lot more than I know about maintenance online. So please do put your questions in the chat box, and then we will be able to answer all of it. Can we get to the next slide? You'll see there's a lot of QR codes on my presentation, and those ones you can, on your whatever device, if you're watching from a TV or a laptop, you can just use your smartphone and you'll be able to scan all of the QR codes to be able to get copies of the Maintenance Act, the maintenance regulations, or there is a new paper by the SA Law Commission, paper 157, on maintenance that will amend the current maintenance legislation the way it is. So, where do we start whenever we deal with maintenance? Or your first question is, how do I apply for maintenance? Next slide. Then what you will usually do is you will go to a maintenance court, and at the maintenance court, you will apply for maintenance on a document called the J101 or a J107 document. Those are the first documents that you start the maintenance process with. And the J101 is for first applications. In the event where you were divorced and you are applying for an increase, then you use the document on the right hand side called a J107 substitution document. So those two are the first ones that you'll be able to use. And what I would like to tell for the online viewers is in the event where you go and apply for maintenance, give as much details of yourself as well as of the father or the non-custodial parent, and then we will be able to either email him or we will be able to in some other way get hold of him via WhatsApp or whatever other social media platforms he's using or she's using, and we will be able to make contact with him. The DOJ Code 26 of 2015 is the Bible for maintenance officers at maintenance courts. And that Bible of theirs tell them that these two forms will be completed in black ink, and when it's completed, the clerk of that specific maintenance court will assist the applicant whenever she is applying for maintenance, and to calculate the amount of maintenance that needs to be paid, as well as based on their means, not just salary, but any other assets that you might have, then we will be able to calculate what the pro rata contributions is of that specific individual. Next slide. So what we first need to do is calculate how much should be paid. And by doing that, we will apply a formula. and that is called the shared expense formula, or whatever the expenses, the real expenses of the child is. That is what we will first then determine. Once we've determined all of those, then we will then take the parents' contribution. We take the salary of the father as well as the salary of the mother, or the means, the estate value of the mother with the estate value of the father, and then we will determine what the contribution in percentage is that each one must comply with and contribute to his or her child. So, what in the event where the person is unemployed? In the event where the person is unemployed, the SA Law Commission paper 157 on chapter 4, page 109 says that in those specific cases, we can also look at in-kind payments. That is where he's not working, but he's got a shop where he sells fruit and vegetables, or whatever the things are that he might be busy with. Those are the things that he can also contribute to the well-being of his or her child. In the event where a person is unemployed, we can also then get the grandparents to get involved. Then we will summon the mother and father of the father, the respondent, or the mother and father of the applicant, the grandparents, in order to then see who can contribute to the living expenses of that specific child. Next slide. So that is what we usually do when we deal with minor children. When it comes to adult dependent children, the mere fact that a child turns 18 in terms of Section 17 of the Children's Act doesn't mean that the maintenance obligations stop there. In that specific case, if a father do not want to continue paying, then he must apply on a J107 to discharge the order and cannot just stop paying, especially if the child is not self-sufficient. There were two cases that was decided in 2022. The Supreme Court of Appeal in Bloemfontein decided in Z versus Z that a mother still retain locus standi to apply for maintenance on behalf of his or her child in a divorce proceedings. In DWT versus MT, the George Court with Judge Saldana decided that in cases involving adult dependent children, that there is still a need for the mother to then pursue the year maintenance or any maintenance in the maintenance court. If the adult dependent child is at university or is at a boarding school, that doesn't mean that the mother or the custodial parent cannot get maintenance. Maintenance will still continue despite this person being at university and being deemed an adult in terms of Section 17 of the Children's Act. Next slide. So the process after the application have been completed, where you submitted the J101 or the J107, is we will summon that specific non-custodial parent, which can be a mother or a father, to the maintenance court. The first form we issue is called the Regulation 3 Directive, and that is how the Regulation 3 Directive look. It is a summons that we send to the, in most cases, the father, to tell him that he needs to come to court and bring a copy of his ID, 6 months bank statements, as well as his proof of income and expenses. And based on that, we will then hold an inquiry and decide how much maintenance he should pay to his minor child or to his adult dependent child. Next slide. In the event where the person do not come to court, we can also then issue a Section 92 summons. This Section 92 summons we issue in the event where the Regulation 3 Directive was not honored by the non-custodial parent. And the reason why we first issue the Regulation 3 Directive is to see if we can't, in an amicable way, try and resolve this issue before we get into having to drag him to court on a Section 92 summons. In the event where he doesn't come to court, when we issue a Section 92 summons, then we will issue what we call a J252 default order on the person, and we can even have a default order on him at the place of employment and have a garnish order, or what we call emolument attachment order, on his salary. Next slide. Um, The reason why on the J101 or J107 we ask for email address or WhatsApp address, in the event where we summon him and we can't get him to court, then we can always try what we call substitute service, where we serve him via email at his email address or via WhatsApp on his WhatsApp address. But in order to apply for a substitute service, we must show that we've tried to get him to court and we failed, and therefore we asked the magistrate to give us an order to use substitute service, because all service should be in person. But in the event where we struggle to get hold of him, we can ask that he be served via substitute service. And that's in terms of Rule 9 of the Magistrate Court Rules. Next slide. Whenever you go to court, or whenever you are asked to go to court, the first thing you need to ask before you go to court the next day or whichever day, within 7 days after you are supposed to be at the court, ask the court if they have a positive return of service, meaning they managed to serve the documents on the non-custodial parent before the actual date. In the event where there's a positive return of service, that means you can come to court and you will be at court. In the event where he's not at court, there will be a default order that will be released and issued by the court against him or her, or that in the event where they don't come to court. This one is a return of service from the family court in Hermanus, and I see my colleague, the maintenance officer of Hermanus, Mr. Mandelake Zweni, is also online, or he was online earlier. I see he's not there anymore, so I'll speak to him later. But I did see that he was online. Next slide. I'm just brought this in to show you the other forms of summons. Whenever you go to a criminal court, they have a new summons form called the J32 summons. And in the J32, you can even apply to lead your evidence via audio-visual link. And you can do the audio-visual link testimony in the event where there's a domestic violence order or you're scared of the person that you have to speak in front of him. Then you can ask the court if you can testify via an audio-visual link in those type of cases. Next slide. So the audio-visual link, the applicant can apply for the audio-visual link and ask that she testify via MS Teams or via Zoom or any of those specific formula. Or she can also ask for an intermediary to assist her during her testimony. Next slide. Um, you can also apply for audio-visual link in maintenance matters, domestic violence matters, children's court matters, or any of those type of matters. Ms. Liesel Khan here had a case in Kyrgyzstan where she was asked to go and testify in a domestic violence matter. And then she managed to, with her attorney, Marie Steenkamp, to organize that they do not have to go for a harassment application in Kyrgyzstan to go to that specific court, but they sit at Belleville Court and then their testimony is being led to the Kyrgyzstan court. So there are people online that know that audiovisual link testimony do work. And the attorney, Ms. Marie Steenkamp, she was the one that led the process in this specific case. Next slide. Okay, so who are the people allowed? Obviously, the mother and father. Unlike the Domestic Violence Act, the Domestic Violence Act says you can have court supporters. Court supporters are not allowed in the maintenance court. Section 10(4) of the Act says only the mother and father and their attorneys are allowed to sit in the maintenance proceedings. Next slide. We are supposed to keep proper record of whatever happens during the maintenance sessions at court, and we do our court records, or we keep a proper record on these two forms that is being shown on the screen now. Next slide. I believe that we should always make sure that there is a proper record. And the one way I believe in a proper record is by recording the session on an app that I use called the Otter app, to make sure that I do not miss any single thing that he says, especially if there might be false information that they give. Then I will have a copy of the recorded version of it. Not all maintenance officers, there are 57 courts in the Western Cape, there are 453 courts in South Africa. Not all of them do it. Some of them just make notes, cryptic notes, and will then later relay those notes onto their record of the proceedings. Next slide. Um, Non-compliance with the maintenance directions. In case there is non-compliance with the maintenance officer's request for specific documents, and the respondent don't bring those documents, then there will be a criminal charge in terms of Section 35 that can be added. In the event where he stays out of, or he doesn't come to court after being served, we can also add a charge in terms of Section 35. Next slide. I believe that in the event where you are scared to speak in court, or where you've got a lot of information to share with the court, please use a Section 12 founding affidavit, where you tell your story from the date that he left the house and how you struggled. All of that you can put in a founding affidavit. Do not go to court and think on that court date you can give all of that information to the magistrate sitting on the bench. Make sure that you give all of that information before the time, and in the form of an affidavit, and that affidavit will be talking on your behalf when you are not in court. Next slide. Lying in expenses. Lying in expenses is backdated expenses. So in the event where where the father did not pay any maintenance for a period of time, you can apply for lying in expenses, meaning backdated from the date that he left and didn't contribute. You can claim for all of those expenses in terms of Section 16. There is a colleague of mine in Belleville, her name is Roxanne Jansen. She wrote an article on lying expenses. You can scan that QR code and you'll be able to get access to that article. Next slide. These are the forms that we use whenever we start our process. We first ask whether the father accepts that he is the father of the child, and then we ask that they complete the formal confirmation of paternity, and then we explain all their rights to them. In the event where they change their address in terms of Section 16(4), they need to inform the court that they've got a new address, and in the event where they do not inform the court, we can then prosecute them in terms of Section 38 for not providing their address to the court. Next slide. In the event where the specific person do not have his bank statements or ID document or whatever, to ensure that the mother goes home with something, we will then impose an interim maintenance order. That is an order that we will use in the meantime in order to get some money from him until we can do a fully fledged inquiry and find out how much he should be contributing to maintenance in that specific case. Next slide. In the event where he agrees to an amount, then that we will do on a form called the J214. The J214 is a consent order where he says, okay, I'm willing to pay X amount. Then he can put that in, as well as the names of the children. Um, After the J214 is signed, then we will have a court order in place. From here onwards, I explain what happens in the event where there's non-compliance. We can either have a garnishee order, or we can take his car, or we can take his cell phone or whatever we would like to somehow attach, we can attach that, or his pension fund, and all of those ways we can and then make sure that we are holding him accountable or we can prosecute him. My other slides are on international maintenance. In the event where he's overseas, we can also then try and get hold of him in the foreign country wherever he is. I do not have time to go to all the slides, but I hope our organizers will be able to make the slides available. And if there are any questions, please, on the last slide, my email address is there. Then you can contact me. I want to give as much time as possible for people to ask questions in case they have any questions that they would like to ask. It is 7 o'clock, colleagues, so I will allow you to ask whatever questions you want to ask. Colleagues, uh, is there anybody that is going to assist with the questions?
Yeah, I have a question or a statement. It's Peter
Yes,
Hugo here. Can you
yes,
hear me?
I can hear you clearly.
Yeah, I listened to what you said about a Sicilian inquiry. According to my understanding, you can correct me if I'm wrong, but according to my understanding, the support, the exclusion of support is only applicable to the Section 10 inquiry. I see no reason why during the Section 6 inquiry, a lady can not have support when they are busy with the Section 6 inquiry because the Act only speaks to the Section 10 inquiry.
Excellent, colleague. I wholeheartedly agree with you on that. But the reality out there is in most courts, there's 57 courts in the Western Cape, or as well as the 453 courts in South Africa. In none of those courts have a maintenance officer allowed another person in the room that is not party to it because of the confidentiality and the POPI legislation and all of those things. I think that is a good point that we can take to the Law Commission and to the Justice Portfolio Committee to ask that the Section 6 inquiry also include the court supporter or anybody else to assist the applicant during that process. But you're completely correct. I agree with you. Um, and Ms. Kanye also says she was never allowed a support person for Section 6. You are correct. Section 10(4) is applicable to Section 10 inquiries before a magistrate, but there is no reason why it should not be allowed in a Section 6. But the way the Act is and the way the legislation, the regulations, and the policy documents are, nowhere does it say that it can be allowed. So because of that, in most cases, there will be an objection by the other party that I'm not willing to speak in front of the court supporter or the other person assisting. But you've got a valid point, and I hope that you will take that to Parliament so that we can get clarity on the Section 6 or whether in the same vein as a domestic violence, because the domestic violence matters, there are two or more court supporters allowed. And then the domestic violence court tell her, no, go for maintenance to the maintenance court. Then those same court supporters are not allowed in the maintenance court, which I feel is unfair. And I agree with you. Section 10(4) is applicable to Section 10 inquiries only. Well done, colleague. I agree wholeheartedly with you.
Yeah,
I
the
see.
Domestic Violence Act actually makes provision for three court support persons in terms of Section 11 of the Act. But my other concern is that, according to my knowledge, again, you can correct me if I'm wrong, you're an expert in this field. With the Directive 3s, the Act is clear. It can be served in any matter or in any manner. So I don't understand, or I've assisted a lot of ladies, but I've never seen it being served in any other matter besides being served by the sheriff. Yet the Act is clear. The MO can serve it in any manner he or she deems fit. So I don't understand why the regulation to your directive threes are not being served via email, via WhatsApp, given the fact that the Act makes provision for it. We don't need to do the substitution application in terms of Rule 9 of the Magistrate Court rules. when it comes to the directive trees or the regulation trees, what we want to call it, because the Act already makes provision for that. So I don't understand why MOs are not exercising their discretion in this regard. It just expedite the whole process.
Mr.Aliteng, completely agree with you in that specific case, and I completely agree with you too that yes, we can use any other means in terms of regulation 3. I used the regulation 3 directive in other courts, including Lutzville, and I can give you an example of where I served somebody with a regulation 3 directive on WhatsApp, and it worked. And within 2 days, within 72 hours, I could get a J214 consent order instead of having to serve it on or get the sheriff to serve it. Ms. Aliteng is already having problems with the service with the sheriff. So, in all of those cases, I agree we can serve it any other means as Regulation 3 says. I agree with you, Mr. Higo. I see there's another hand up, Rahim and Associates. You can ask your question. Please unmute yourself.
Good evening, advocate writers. Peter Ihu. That's Rani speaking here.
Yes, Rani.
So basically, I just wanted to know, I asked the advocate writers for some advice as well as Peter, with a matter where the clients went to court and it appears that there was a consent order made. And so the consent order, we believe it was made in May, because they had a court date in May of 2025. So the father, basically, it was a case of child maintenance. The father only made one payment, and he's actually stopped paying now until now. And the mother then went to Belleville Magistrates Court, and they told her that she needs to apply for a garnishee order. Now, the question was, how do you even apply for a garnishee order, and how do you what information do you put in the affidavit? Because the court does not have any record of how much the salary of the father or the mother is. No exercises were done, no investigation was done. So how do you even get to applying for a garnishee order, and what do you ask for?
Okay. What you do is you complete a J470 form. I will send all of those forms to you, colleague. Um, Uh, Ms. Hicks, yes, it's a pleasure. You need to thank Advocate Pillay as well as the Guild for organizing this session. They are the organizers behind it, Wesley Guild organization, as well as Ms. Advocate Pillay of the Office of the Family Advocate, Cape Town. They are the organizers. To get back to Arnie's question, in the event where you want to garnish your order, you complete a J470 form as well as a J306 form. Those forms are all available on the Department of Justice's website. Once you complete it, then you submit it to court with a founding affidavit. In your affidavit, you mention that you'd like to get a garnishee order and he's working at whichever place, and then they will make they can do it one of two ways. The one way is they can make an order and send it to the employer, and the employer can say whether he's earning more than the amount that is being requested, or they can do what we call a rule nisi order. A rule nisi is where we warn the father as well as the employer that we want to take the money from his salary, and then the court will give a return date. On the return date, he needs to come back. If he doesn't come back, the court will make an order in his absence and send the a form called the Form O, the J448, to the employer, and on the J448 the amount will be indicated, and the employer have 14 days in which they can say whether they can comply with that order or not. In the event where they cannot comply with the order, they need to come back to the court on a form called the J453, and they will then have to apply for an amendment to the order or for a lower amount that is in compliance with his salary. Honey, I'll send you all the forms, the J417, the J306 after this session, and make sure that you have a copy of it. I see Dr. Bayers asked for a copy of the presentation. I will make it available to the doctor after the session, and make sure that you do get a copy of it. In the event where you want to, you can also ask the host. They do have a copy of my presentation in case anyone would like to have a copy of it. Are there any other questions? You can also ask questions for um, Advocate Pillay. She's also online. Okay, Ms. Hicks, we will make sure that we get you a copy of the presentation after the session. Are there any other
Thank you,
questions?
Advocate. Thank you,
Please.
colleague, for referring to me. I appreciate
Okay.
the opportunity myself. I also want to indicate that I'm happy to answer questions on email as well. If anyone wants to go back and think about it and revert, I've provided my email address to Isa to make it available. So I'm happy to do that.
Thank you, Advocate Pillay. Masali Teng, I've sent a better one to you yesterday, but I will make sure that you get this copy since you always want to get all the information. I will make sure that you do get a copy of it. Don't worry about it. Ms. Hicks, I've got your email address. I will make sure that we send you a copy of the presentation. Are there any other questions that anyone would like to ask? Advocate Pillay put an email address in the chat box, as well as my email address is also in the chat box. Please reach out to us and we will be able to provide you with any of the forms, but just be clear on what form you'd like. Or just if you have the presentation printed, once you print it, you can use your smartphone to scan the specific form in, and you will have a copy of it. If your family or somebody else needs a copy of it, just print that set of copies, and you'll be able to get the copy of that specific form on your smartphone, and will be able to complete it on your smartphone in the event where you need to complete it. Are there any other questions?
Hi, Advocate um, Dion. I had a couple of questions. Just wanted to follow up one on the one of the garnish. So if you had a standing order and the person keeps on, they'll send this month, they're not sending that month. When you going to back to court, are you applying afresh with all the details, or is the process different? And then the second question I had, what happens in a case where one party has a lawyer and the other party does not have a lawyer? So what happened with my case, I applied for maintenance, and then the respondent came with a lawyer, and the whole setup, I did feel that the maintenance officer was more leaning towards the side that had the lawyer, in terms of how the whole thing was conducted. However, luckily for me, I had a bit of background, and I managed to um, continue with the situation and asked for someone else to do pro bono, but they were in a distance, communicating with the lawyer. So usually, I feel what happens in court sometimes, especially for when it comes to the applicant, is that they already financially stretched, but they're unable to find a lawyer, but they also at the same time not within the cap for legal aid to get assistance. So what happens, what if you as an applicant feel that you are in a position when you're being compromised, based on the other party having a lawyer and you not, and you feel the officer in charge i- is sometimes biased. Is there recourse for you as a person, or you just have to hope that things work out at the end?
No,
Thank
you
you.
do not. Thank you so much for your questions. First of all, you do not need to have a lawyer there unless, obviously, in the event where you have a lawyer, then you can appoint a lawyer. But in most cases, I prefer to tell the parties, do not come with lawyers. It just make this matter longer because we need to, in terms of Section 15, apply what we call fair and equitable. If you see that process is not fair and equitable and that the a maintenance officer is listening more to the attorney and to the respondent and not to you, then you can quote Section 15 and say, no, but this is not fair and equitable towards me. And you do not have to agree to anything in the office of the maintenance officer. If you're not happy with it, you can always go to and say you want to appear in front of a magistrate, and then you can bring all your information in front of the magistrate. Your question pertaining to the background information and all of it, it's that's why I showed the affidavit earlier. So please maybe have a look at that affidavit. The more information you give us that we can use at a later stage, the better it is. Even if you repeat some of the information of what happened prior, then it will be in your benefit where we get a full picture of what is going on in that specific person's life or in your life in order to help you. Unfortunately, the legal aid board will not give you legal aid in the event where you earn more than 9,500 per month, or where you have got assets, a car, or anything more than 160,000. If you have a house that is valued more than 754,000, not even a million, then you will not qualify for legal aid. So that's unfortunately the legal aid threshold, and which makes it a little bit more difficult for you to then gain legal aid. But Section 28 1H of the Constitution says that in any case involving a child where that child's future is at stake and that proceedings might be detrimental to them, then you can apply for a legal aid officer to assist you. I've assisted mothers in the past to apply for legal aid. You might not get over the threshold, especially the if you earn more than 9,500. In those cases, what I always tell the mother is uh, appeal against the legal aid board's decision not to grant you a legal aid. And in most cases, on appeal, I found that some of these ladies do get legal aid once they see that the future of that child might be at stake in the event where they do not grant that specific person legal aid. But in most cases, I do not want to create false hope. In most cases, you're not going to qualify for legal aid when you apply for legal aid, unfortunately. How do you calculate future maintenance? It's a difficult process. I cannot explain it all now in this specific case, Rani, but I will send you information on how to calculate future maintenance. Or maybe if the OFA Advocate Pillay, as well as our colleagues at Wesley Guild, can organize another session specifically on future maintenance, then I can advise you on future maintenance, how to calculate it, and show you all the case law pertaining to it whenever we deal with future maintenance matters. Ms. Arliteng already says, please, it would be great if we have such a session. So, colleagues, Wesley Guild, we've got already a request that we have a session on future maintenance. Ms. Pillay, you'll have to assist over here. Any other questions? Peter says the legal aid means test is prima facie discriminatory and infringe on children's in civil cases, Section 9 constitutional rights. I do agree with you. But while a child accused of criminal proceedings is given a legal aid and in child justice proceedings, that is still, the right to equality have not been tested pertaining to this specific provision, and there haven't been a case that went on um, appeal to the High Court or to the Constitutional Court to specifically deal with the right to equality. But hopefully, or maybe we can start something, Mr. Yiku, and get such a case where we show that it's unfair of mothers fighting for children that they do not get a legal aid being assigned to them, especially in maintenance matters. I wholeheartedly agree with the comments of Mr. Peter Yiku. Are there any other questions? Arani's, Arani's your hand up, or are you saying that's okay? You can speak?
No, my hand is Advocate Reuters. My hand was actually up. So
Yes.
about 2 years ago, so I do social work, social working.
Yeah.
So we had this maintenance matter, and well, this so the parents went through a fasakh. So it's your Muslim. It was your Muslim marriage. The mother left without anything. She left the daddy with a house, and she took the two kids with. So the father never paid maintenance. So she did it all on her own. She had to like get a new place to stay for them and everything. So now the father remarried, and then after he remarried, um, she took him then to the maintenance court. So the court said, listen, this is an adult child. He was around between 21 and 22 years old. So they told them no, he needs to apply for maintenance. But I do remember that there was this incident where the father said he's getting legal representation from legal aid, and then the court denied the son getting the legal aid representation. The son was only casualing and he was studying. And then the father said, but he doesn't have enough money to pay maintenance to this child. And I just feel as a social worker, I could have done so much more for them if I just had to be present there because I knew how they were living and what they were eating. And I mean, they were basically just surviving and try to make it through the month because mommy had to cover everything, school fees, studies, everything, and verblyf. So they're
Yeah.
lodging as well. And I
Yeah.
just feel you have my full support if you really decide on doing anything. I mean, it was a Muslim marriage. I'm very passionate when it comes to Muslim marriages because I know almost all of the time these ladies get absolutely nothing out of the deal. And father sitting with the house, they sit with all the assets, cars. And yes, that's very, very wrong.
Yes.
So I'm on board if you ever decide that you're going to take it further. You and Peter advocate.
Thank you so
Okay.
much. There is a case
Thank you.
that we are busy dealing with that we want to get enrolled in the Western Cape High Court that is with the Legal Aid Board now. We've just concluded the provisions as far as the legal aid granting a legal aid in the High Court, where we are specifically looking at the fasakh, because what happened is the lady got a fasakh, but because the husband did not give the talak, the fasakh, even though it was concluded, the enforceability of it is not being adhered to in this specific case because it was a fasakh and according to the man, he's still married. So we are taking this matter to the High Court, and as soon as it's going to be heard in the High Court, I will let you know about it. But there is currently a matter that is about to be enrolled in the Western Cape High Court pertaining to fasakh and talaks of Muslim marriages. So I will keep you informed of that specific case, Rani.
Thanks, advocate. So there is, if I can just add, there is a difference between the fasakh. So when a woman applies for a fasakh, it's almost like she's walking out, she's choosing to leave.
Yes.
Maybe there was that little bit of argument and that gap that only the ulama, and this is your Muslim learned scholars, can maybe explain. So I know quite a few, and they would be able to give a lot of valid input to this case.
Yes, well done. Thank you. Well, put me in contact with them so that
Definitely.
we can speak to the Legal Aid Board of South Africa and then
Yes,
deal with it. Thank you, Arnie.
pleasure.
I see there's another comment by Peter here, who hopefully, if everything goes well, then the law will be amended, extending locus standi to social workers to apply for maintenance on behalf of children. It's in the law report. That's correct. Paper 157, Chapter 5 says that applicants will in future also include social workers or anyone that have a vested interest in the well-being of a child. All of them will be allowed, when the Amendment Act is in Parliament, that they will be allowed to bring applications. So the application do not have to be just brought by the mother or the grandmother or the aunt, can also be brought by the social worker once the Amendment Act is passed in Parliament. So yes, I agree with you, Mr. Yichu. It's a a good movement as far as maintenance is concerned in South Africa. It's already almost 7:30, Ms. Mdingi. If there are no more questions, or what, at what time are we going to be online? You are muted. We can't hear you, Ms. Mdingi.
Um, I was about to say, advocate, Dion, that we can conclude now because the hello, can you hear me?
Yes,
Hi,
we can hear
Advocate Dion,
you.
can you hear me?
Yes, I can hear you.
Can
I hear
anyone
you.
hear me?
I hear you.
Hello? There are no
Yes.
questions on Facebook, so we can conclude the session. If there are any last words you would want to say, and then I'll hand over to Advocate Pillay. If she has any last word, then we can conclude on the session.
Well, all I want to say is please entrust the maintenance courts in South Africa with your maintenance matter. If it takes too long, please, you have got a right to complain. The complaint you can send it is to servicedelivery@justice.gov.za. I will put it in the chat box. You can always send your complaint to the Justice Service Delivery email address and tell them at which court your case is and whatever your complaint is with that specific court. But we are over there to help you. Do not appoint an attorney. We are supposed to be there to look after the best interest of your child. Thank you so much, colleagues. Advocate Pillay.
Thank you, colleague. I want to once again say thank you for the opportunity to address you all. I actually um, haven't touched fully on all aspects, and if there's any further queries that anyone has, you're welcome to email me. I've put my email address on the chat there, and I'm happy to engage with you if there are specific questions. Thank you very much once again for the opportunity.
Thank you very much, Advocate Pillay and Advocate Dion, for your time. Um, I would say that we'll keep on coming to knock on your doors because this is an informative session that has to continuously be done. It can be done as a once off because each and every year there are new people encountering such challenges. So would love to have you, and also when the new laws have been updated, that you come and inform our audiences and our congregants as to how they can benefit from the new laws that are there. From the rest of the Wesley Good team, we thank you very much for dedicating the time and for everyone who is engaged on this issue. May we continue to strive for what is in the best interest of the children in our society and work hand to hand together. Thank you very much. And for me, I thank you for your time, and that is goodbye from us.
Goodbye.